Hi, I'm Tom Bradford. I'm a lawyer and barrister, and in this video I'm going to show you how to complete the online appeal form against an immigration refusal in the UK. So let's have a look at the form. If you need to find the link to this form, I've got it just below this video with my contact details. This is the first page you'll see. It sets out the kinds of decision against which you can appeal. This is because there's no automatic right of appeal to the Immigration Tribunal. Your decision letter should normally tell you whether or not you have a right of appeal, although the Home Office does sometimes get this wrong. You should take legal advice in all cases. Most immigration applications do not have a right of appeal. Instead, if they are going to be challenged, then this should be by way of administrative review or judicial review rather than through an appeal. I have separate videos coming out after this on how to complete the administrative review form and on how to bring a judicial review claim against your decision. Do remember that if you are in the UK, then your appeal must be lodged with the tribunal within 14 calendar days of the date that you were sent the notice of decision. If you're outside of the UK, then you must appeal within 28 calendar days from the date that you received the entry clearance decision. There are very limited circumstances in which you can apply to the tribunal to extend the deadline for appealing. So don't hesitate to contact me or email me if I can be of help. It's important that you take legal advice before submitting this form, and you can find my email address below if you'd like a free initial consultation. As for the options this form gives you, it says, please select from one of the following options. The first of these is, I have received a decision to refuse my asylum protection human rights claim. So if you have received a refusal of a protection claim, so a claim that your removal from the UK would breach the UK's duties under the Refugee Convention, then this is the relevant option. Or if you have received, for example, a refusal that your claim of humanitarian protection should be granted, then this is the relevant category. This also applies to human rights claims, in other words, claims that your removal from the UK would be unlawful under Section 6 of the Human Rights Act. These are all matters on which you would need to take legal advice before proceeding. The second option is this. I am in the UK and I received a refusal decision on an application made before the 20th of October 2014 as a Tier 4 migrant, or an application made before the 20th of October 2014 as the family member of a Tier 4 migrant, or an application made before the 2nd of March 2015 as a Tier 1, Tier 2 or Tier 5 migrant, or an application made before the 2nd of March 2015 as the family member of a Tier 1, 2 or 5 migrant. I'm going to deal with this relatively quickly because as time goes by, it's increasingly unlikely that these will be relevant. Basically, when the Immigration Act 2014 was introduced, its commencement was phased. Firstly, it applied to Tier 4 students and their family members who had made an application for leave to remain on or after the 20th of October 2014. So these, the first two types of decision here are applications made before that time, so before the Immigration Act 2014 came into force. As for the second two subcategories, on the 2nd of March 2015, the appeals regime was extended to all Tier 1, 2 and 5 applicants and their family members who had applied for leave to remain on or after that date. So again, the second two types of decision here are for old applications made before the 2nd of March 2015. The third option, which is likely to be more relevant in many cases, is I have received a refusal decision dated after the 6th of April 2015 on an application for leave to enter, or an application for entry clearance, or an application for a certificate of entitlement under Section 10 of the Nationality, Immigration and Asylum Act 2002, or an application for a variation of leave to enter or remain with the result that I have no leave to enter or remain. This is the more relevant category for most people in that it covers most applications. So from the 6th of April 2015, the appeals regime under the Immigration Act 2014 is applicable to everyone who applied for entry clearance to come to the UK or permission, that is leave, to enter the UK or remain in the UK. It is also applicable to everyone who applies for a certificate for a right of abode on or after that date. This is the next option that the form gives you. I have received an appealable decision on any other application type from in or outside of the UK dated before the 6th of April 2015. Again, this is unlikely to be relevant now to most of you, as a good deal of time has elapsed since the 6th of April 2015. The next option on the form is I have received an appealable decision on any other application and the decision is dated on or after the 6th of April 2015. So one example here is going to be certain appeals by European Economic Area nationals and Swiss nationals, including their family members and extended family members. This does not include British citizens who don't have any other EEA nationality. The EEA regulations give a right of appeal against what is referred to as an EEA decision. This is one that concerns your entitlement to enter or be admitted to the UK, your entitlement to EEA documents, which means, for example, registration certificates, residence cards, derivative residence cards, documents certifying permanent residence, and lastly, permanent residence cards. So that's the first page of the online appeal form. In the next video, I'm going to have a look at the grounds of appeal, which you need to complete in the rest of the form. I hope this video was helpful. Thanks for watching and see you in the next video.